You might think marrying someone from another country means they will automatically be able to come live with you in the United States, right? Well, in 2025 through 2026, that assumption has been turned upside down. A wave of travel and visa restrictions from the US government has made it much harder and in some cases nearly impossible for US citizens to bring their foreign spouses into the country if those spouses are from certain nations. Today we are breaking down the facts, not rumor, not fear mongering, but documented policy changes and why families are being separated. Historically, US immigration law has allowed immediate relatives, including spouses of US citizens, to enter the United States on family-based visas like the CR1, IR1 immigrant visas. Once a US citizen files an I-130 petition and it's approved, the K3 non-immigrant spouse visa and K1 fiancé visas have also been pathway for couples, but beginning in June 2025 and expanding into 2026, the US government issued presidential proclamations and State Department actions that dramatically limit or even suspended the issuance of visas, including spouse visas for citizens of various countries. This is not a trivial update, it's a broad policy shift affecting millions of couples globally. Visa restrictions are grouped into two major categories. For full ban countries, for these nations, US consulates are generally prohibited from issuing almost all visas, including marriage-based visas. This affects both K1 fiance or fiancé visa and CR1 IR1 spouse visa under the presidential proclamation. Countries under these categories include Afghanistan, Burma, Myanmar, Chad, Republic of Congo, Equatorial Guinea, Eritrea, Haiti, Iran, Libya, Somalia, Sudan, Yemen. For people from this country, even if a US citizen is married to someone from one of these nations, they will face denial of visa issuance at the consulate. For partial ban countries, these countries are not completely banned, but immigrant visas and many non-immigrant visas, including spouse visas, are severely restricted with higher denial risk and longer processing delays. So these countries are Burundi, Cuba, Laos, Sierra Leone, Togo, Turkmenistan, Venezuela. In many cases, consular officers have broad discretion to refuse even legitimate spouse visa cases, making the process unpredictable. Then in January 2026, the US announced a pause on immigrant visa processing for up to 75 countries, which includes large nations like Brazil, Iran, Russia, Pakistan, Nigeria, Somalia, and more. This pause covers family-based immigrant visas too, meaning spouse green card are stuck in limbo for many couples. This action is not officially called a marriage ban, but because spouse visas are part of immigrant visas, many US citizens cannot bring their spouses from those countries while the pause remains in effect. Let's be clear, these policy changes are not just immigration bureaucracy. They are life-changing for real couples and families. Long-distance marriages without a timeline. Couples who plan their lives together find themselves forced to live apart indefinitely. Even after getting married, things that used to take like 6 to 12 months, like obtaining a CR1 visa, are now stalled or outright denied for many nationalities. Automatic exemptions are gone. In the past, if you were the immediate relative, like a spouse of a US citizen, that alone generally guaranteed eligibility for a visa. That exception has been removed or severely narrowed for many affected countries, meaning marriage itself may not be enough to get your partner into the US without additional evidence or waivers. Clear and convincing evidence standard. The US government has raised the evidentiary standard for proving family relationships to clear and convincing evidence, a much higher bar than before. That often means DNA tests, exhaustive civil records, and long waits while consular officers make complicated decisions. So are there any exceptions? Yes, but they are limited and often unclear. Diplomats and certain official diplomats, major international event participants like Olympic athletes and a few other categories may still receive visas. Lawful permanent residents, which are green card holders, people who already have green cards, are usually exempt from some travel bans. Dual nationals, if your spouse has citizenship in another country not on the ban list and uses that passport, they may be able to enter. National interest waivers. In rare cases, the US government may issue a waiver for a spouse if entry is deemed in the national interest, but these are few and unpredictable. Importantly, none of these exceptions are guaranteed. They are discretionary and vary by case and by consulate. What if you are already married? Here's the twist. Policies are constantly evolving. Some couples already living abroad with pending applications are being told their visas won't be issued until after review or until a waiver is granted. Others are being told to reapply or provide more evidence. And in some situations, like where travel bans overlap with broader visa pauses, even reapplications are being refused. This means that the US citizen's ability to sponsor a spouse is no longer automatic for large sections of the world. There have been legal challenges to the travel ban and visa restrictions. In some cases, courts have ruled that the government cannot refuse visas based on certain interpretations of the law. But here's the bottom line. Even if a court limits some aspects of the ban, consular officials still have wide discretion and the policies have not been fully overturned. This leaves many couples in a messy legal landscape where rights, policies, and interpretations are all in flux. What can couples do right now? What couples can do right now is to get accurate legal advice, speak to a qualified immigration attorney, experience with family visas and travel bans. Laws changes frequently and individuals' advice is vital. Prepare strong documentation if a visa interview is possible. Make sure you have exhaustive proof of identity and genuine relationship, including photos, communications, cohabitation evidence, and if possible, DNA results. Explore third country options. Some couples are married in a third country and using those legal documents to refile petition. Though this doesn't guarantee success under the bans. Stay updated, the situation is evolving. The policies might change again in 2026 and beyond. Is this permanent? At the moment, these travel and visa restrictions remain in force. They reflect a major shift in US immigration policy, focusing on stricter vetting, national security and other criteria. But policies can and do change, either through future executive action, legislation from Congress, or legal ruling from the court. For now, however, US citizens cannot automatically bring spouses from certain countries to the United States, and in some cases, it's nearly impossible without real expectations. I hope you find this video helpful. If you do, kindly like, share, and subscribe, and I'll see you in the next one. Bye.